Hello, everybody. Thank you for joining Graham and I today. If you haven't watched any of the videos on our YouTube channel, the divorcemagazine.co.uk YouTube channel, please go on there. There's a lot of information from divorce professionals that I have managed to put together for all of you. Some of you have sent in questions and we've created videos around those questions. So do visit the divorcemagazine.co.uk website and the YouTube channel as well. My name is Soila. I'm the founder and editor of the Divorce Magazine.co.uk, and today I forget to say, I work as a child or parenting therapist. So if you're going through a situation where you're struggling with or finding the co-parenting situation very challenging, just give me a call and we can take it from there. So today we have Graham, and Graham, I'll let you introduce yourself.
Oh, hi there, I'm Graham Fletcher. I'm a McKenzie Friend, and we're going to talk a little bit about what I do as a McKenzie Friend, helping mums, dads and grandparents in family courts throughout the sort of southeast and around the bottom end of the UK. So hi there.
Hi. Okay, so great. I can hear Nick. Okay, it's gone. One of the things I'd like to ask you is, what is a McKenzie Friend? If you can tell us what that is all about, what role they play when it comes to divorce.
In a nutshell, McKenzie Friend is... Oh, sorry, I could hear what I was saying there. So, in a nutshell, McKenzie Friend is somebody who supports mums or dads who find themselves in a situation where they're having to go to a family court to resolve a dispute that they're not able to do with their ex-partner with regards to their arrangements for their children or the financial matters of their divorce, effectively. So everybody has a right to have somebody accompany them to court, to take notes for them, to help them emotionally prepare beforehand. And if, for example, you find yourself in a position when you're going through a divorce and separation and there isn't an amicable sort of solution to the situation, and you've tried mediation, and for whatever reasons mediation has failed to be successful for the pair of you, then sometimes the only step that you've got able to resolve that dispute is to go to the family court. And so you're either faced with a choice of employing a solicitor at the rates that the solicitors do, or you can seek the support of a McKenzie Friend. My role and my background as a McKenzie Friend is that I'm a sort of trained mentor, and I've got experience of working with children and families for 15 years plus as a youth worker and a play worker, and I've got lots of experience of knowing how social workers work in relation to childcare cases. So I have a wealth of experience that I kind of bring to a situation, and I've also been through the family court process myself as what's called a litigant in person. So if you go to court on your own and you choose to present your own case to the court, you're called a litigant in person. If you go to court and you ask a solicitor to represent you, they're effectively presenting your case on your behalf. When you go as a litigant in person, you are the person sitting in front of the judge or the magistrates, and you're presenting your own case. So as a litigant in person, I can be there to, what I do is a lot of help with document preparation so that people can understand what the key facts and processes are that a family court case will go through. I can advise people on how best to present themselves in that documentation. I can then advise them how best to present themselves when they're talking to social workers from CAFCAS organisation, which we can talk about. And then I can also give them advice on how to best present themselves to the judge. And there is a lot of successful situations that I've been involved with where people, I'm able to mentor people and coach people to realise that they can get a successful outcome at the end of something in the family courts just by learning and educating themselves. The majority of it is educating them what not to do, how not to present themselves. family courts work in a particular way. They're very black and white and factual, and they're very interested in fact, and they're very interested in, and a lot of people going through divorces and separations aren't necessarily thinking like that. They're thinking about, my ex-partner said this, the children did this, and so people can turn up at family court and be presenting information that a court may not find that they're going to put a lot of weight on. So that's a short introductory summary to what I do as a McKenzie Friend.
That's really interesting. So when you do get into court, I mean, by the time a couple gets to court, I can imagine that the emotions are running so high. So it is possible, because like in mediation, you can find that already when the couples come together, the emotions are quite high, and they can use that mediation session as a means of telling their own stories, and kind of like, I don't want to say waste time, because for them it's really important to give out this script that they have.
Sure.
By the time you get to court with your client, I think you would call him or her, do you speak up for them, or do they do it themselves?
No, they do that themselves. I will advise them on how to go about doing that. I'm very clear, and if somebody is presenting their own case at court, that is what they're doing, and I'm there to help them present that as best they can. Okay. I do describe going to court as having two kind of paths, or two kind of functions, and I like to debunk to people ultimately what that experience might hold. I do see and experience the family courts as quite often in one factor being an extended form of mediation. Okay, so that the courts are very much always seeking to encourage two parents to come to an agreement that they both have some participation and agreement in what they're agreeing. Now, sometimes at mediation, what happens is that people don't want to be in mediation. They want a far simpler answer. They want a far simpler solution, or they only want their solution, and they don't want the other parent's solution. Now, and that's sometimes, even if mediation does come to an agreement, and an agreement's written up, if, for example, one of the parties decides a month later that agreement's no longer what they agreed to, then it completely falls apart. So when you go to court, quite often what happens is both parties are a little bit uncertain, or they're a little bit overawed by being in front of court. They may even have a concept that they're on trial, and it can be a very unsettling experience for some people. But effectively, a court will always be talking to you as both parents to, let's try and resolve this, because if you cannot resolve this dispute, which may happen over numerous court hearings, the judge will warn both parents, I will need to make a judgment on this if neither of you can resolve this dispute, and therefore you both take the huge risk of whatever I say is my judgment, you are ordered to follow. So it's far better for you to come to a practical agreement. Sometimes some people may feel that they're coming to that agreement slightly under the duress of the experience of court, but nevertheless, more often than not, they will be the court experience will recontextualize the context of which the dispute is happening in. It's now started to get a bit more serious. It's started to get a bit more formal. It's had a start point of the application that's going into court, and it therefore at some point will likely have an end point. And so it's better to be participating in that end point by some sort of consensual agreement, and then the court can then write up and map out that agreement, and that can then be written up as a court order. So that is one function of the family courts, is that in some ways it's this extended form of mediation with slightly different people and context around it. And I think I try and make sure to a lot of people that I'm helping, if you can try and understand this, every document you write to court should in some way be able to be read by your ex-partner as a negotiation document, as something which is building a path back to getting on as a separated parent, rather than being at war, which some parents may psychologically be in that kind of place. If they stay in that psychological place of kind of being at war, and they may have a position of that they don't want the other parent to see the child, then court cases become more complicated. Evidence needs to be provided of any claims that are being made, and then if there is still a dispute and a judge says, we're going to have to consider this in some detail, we have a much longer hearing, and I will have to come up with a judgment at the end of this. Okay. So a lot of what I do is really about emotional support. It's asking very upfront, honest questions about situations. It's being able to help my clients understand if somebody is submitting something to a court and claiming it as evidence. It's for me being able to debunk to them, will a court actually see that as evidence, or is it generally conjecture? Is it one person's opinion? Is it a provable fact? And I work in many situations where people come out of court with me and they say, "Oh, I previously paid a solicitor in this case. You've given me lots more information and understanding about what I've been going through, and I've come out of it with either better results or, just what I was looking for. But I felt in so much more ownership on the day, and I do work with a number of parents as well who are also, I'm a separated parent myself of 2 children, and sometimes the support that parents seek from me is just about how I've coped as a separated parent, what observations I might have about their kind of situation, and some people have been very grateful of that advice, because obviously I've got a background of working with children and families for 15 years, so that is something that I feel I bring to it, and I'm very honest and clear about situations where sometimes people can be tying themselves up in with loads of minutiae of this shared relationship that they have with the other parent, and sometimes I'm always encouraging people, no matter what, to try and somehow see a way back out of that conflict, because ultimately in 10, 15 years, they're still going to be the parents of both those children, and so they do ultimately really need to work towards there being a better solution around all the children in the family. So that's a bit of an oversight. Again, I'll put a full stop in the sentence there.
Okay, so if you're consulting, I suppose, with the parents with your client who's going into court, do you accompany them to court, or do you just prepare them and then they go off on their own, or do you do both?
Part of it is the accompanying some to court. So typically I would meet somebody an hour before a court hearing. Typically, it's quite common in an hour before a court hearing that the parties, if, for example, the other person has a legal representative, they may well come and speak to you and see if there's any common ground or negotiation or points for improvement that can happen. And I have been to court on numerous times with people whereby they've made a court application because there was a dispute or mediation wasn't working, and when they've turned up on the day before they've even gone in to see a judge or a magistrate, they have been able, with either myself as a McKenzie friend or the solicitor, going back and forth between both parties and being able to map out an arrangement for example, for the children, and when the children are spending time with both parents, they've been able to do that in such a comprehensive way that they've thought about the whole academic school year ahead, and they've really mapped out exactly the way in which the children are going to spend time. And it's very crucial to realise that courts are always focused on the children in the middle. They may have 2 parents with strong views about the children in the middle, but they will be always trying to seek to think of the children in the middle and what is the best solution for them. So a lot of what I do in that, so it's great when you can go to court and quite quickly an order is kind of made outside the court, and then you can go into the court, present what arrangements that you've come up with, and that can then be written up within a court order. So both parents have a copy of the court order, and that sometimes at court, both parents will be interviewed by a CAFCAS social worker, who's a court-appointed social worker, who will ascertain whether or not there's any concerns about the children's welfare. If they do feel there's been some expressed concerns about that, they will seek to perhaps recommend a significant report needs to be filed with the court, so the court has further information to consider. So I can advise, parents around that. Sometimes it's just really there's a lot of it is this emotional support at court on the day. But what I can do as a McKenzie friend is also talk quietly whilst in the court.
Okay.
So I do a lot of pre-preparing and sort of predicting what may be the options in court, and then as they're happening in court, I can double check with my client. Do you recall, like I said, this might happen, this might happen. You have a choice here. You can say yes or no. I will also be making notes, because more often than not, when somebody's in court presenting their own case, when they get out, their brain's scrambled. Somebody said something emotional that's triggered something in them, and it's difficult for them to keep track.
Yeah.
So a lot of what a McKenzie friend is doing is saying, what do you want in advance to happen at the hearing? Okay, that's your target, that's your aim, and how can I help you achieve that on the day? So, for example, if you completely forget to mention one aspect, which is actually quite crucial, I can be there kind of reminding you of that, and we can have pre-brief notes that we've worked on collaboratively. Sometimes I've even had to kick or nudge people under the table in order to tell them to be quiet. Because they're actually starting to say that things that are not helping the situation as well. So a lot of what I'm trying to do is really help the court hearing be more effective for the children in the middle, and for there to be a positive solution that comes out of that particular hearing.
Yeah, and for the parents to put their cases forward, in the most clear way possible, without going into the whole back history of what has happened. Does a McKenzie friend provide legal advice?
No, I don't say that I provide legal advice. I think, there is a remit and restriction on legal advice. And, if you want legal advice, I would advise that you go to a trained legal professional for that. What I can do is advise you on the processes of court that court generally follows in childcare matters or financial hearings, because I've been through the experience of that on my own and with other people. So I know that this, if you go to court and the dispute doesn't look like it's going to be resolved that day, the court will map out the direction that court hearing needs to go in, so that it will set out whether it needs statements submitted by both parties. It will give you dates by which you both need to do that. If there's any reports needed by social workers, they will possibly direct that. And so the second hearing you come back, some of those bits of information will be provided. There's still an opportunity for both people and both parents to come up with some sort of solution. Sometimes parents in dispute may have made allegations, or they've expressed their point of view to the social worker, and ultimately the social worker will write up a Section 7 report which will give their professional oversight on those, whether or not it could well. Sometimes it's reading between the lines. Sometimes they may be saying between the lines it's clearly a dispute between both the parents, rather than there being issues for the children in the middle. And it might be another situation where, again, that report is written in a way that is still trying to encourage both parents to come up with a solution, rather than the judge be forced to make a final solution to this dispute.
So in a way, you act as a buffer between the judge and the litigants in person.
Yeah, I mean, my main aim really is to make sure that whatever a judge says to the person I'm supporting is, do they fully understand what they're saying? Do they fully understand the point where they're at in the process? Because I will have already pre-spoken to them about that. So it's just making sure that they're informed before they go about what the processes are. When it's happening there and then, things can happen quite quickly in court, and so it's about being prepared in your paperwork. The more organised that you are as a litigant in person, in the actual paper documents, those are kind of key to how to represent yourself in court, is knowing how organised And if the case, unfortunately, gets more complex and becomes a longer hearing, you're going to really, really rely on that paperwork, which is called a bundle. So that bundle will be the key point of reference with which you say, this is the paper evidence that I'm referring to. And now, when I'm talking in court, I'm talking about the paper evidence that is already written in front of the judge.
Okay. Sorry. Do you help your clients fill in the paperwork? The forms?
Well, the paperwork that I'm referring to, I mean, I can help clients with making applications.
The divorce papers.
If they want help filling in the application forms.
Okay.
I can help my clients typically with position statements, which is a document where you state your position on the day.
Yeah.
And so I tend to do a lot of work that's about reviewing documents before that happens.
Okay.
And sometimes if somebody's going for an enforcement order, I can support them with that paperwork as well. So I tend to work in a collaborative way, that I don't start off writing the document. Yes, it's somebody else's case. I say, you write the document to the best that you can, and then if you send it to me for review, I can help you with sort of my observations on how this is going to be a more effective document for you. Because you told me what your aims are, I will send back an amended document that they will go, okay, that's much clearer, it's much more effective, it's much more chiselled down and kind of neater, and it makes its points in a far more kind of precise way.
Okay. And does a McKenzie friend negotiate with the other parties?
So sometimes this is all very dependent on if I go to hearing and there's two litigants in person, so both parents are presenting their own cases. I will always go and introduce myself and say hello. I will impartially explain my role, and if there's any way I can be a go-between between two people. Sometimes two parents may not want to speak to each other face to face, so I can potentially sort of go between one person and the other with a piece of paper and sort of help kind of chisel out some sort of arrangement. There might be some sticking points on particular issues, but yes, I will. But that's all outside the courtroom.
You've mentioned a couple of times how you've touched on it, how you became a McKenzie friend. How did that come about?
It was just through a process of going through a separation myself, and not being in a financial position to afford to consult solicitors. So through just educating myself on the internet, and I had a McKenzie friend that supported me on numerous occasions, and I just sort of educated myself to apply some fairly straightforward sort of principles and concepts, my children now live with me and their mum equally. I'm very blessed and grateful for that situation, and it can be a very tricky role being a separated parent, and so it's just something that I've kind of, with my background of helping children and families and working professionally with people, I've kind of sort of developed a leaning towards that, and I've got a good kind of written eye, at kind of reading documents and writing. So it's kind of a good combination of my kind of skill set, really. And I really like a situation where I can help people and they can come out of it with a solution that they're happy with.
Yeah.
I get some really good feedback from my clients that I regularly post on my website and my Facebook page from people saying it really made such a difference to get the advice from you. They appreciate my insights about how it works. It can be much more tricky if I'm helping people who are very focused on negative history, negative dynamics between themselves and another parent. I will always try to be very honest and helpful as much as I can. Some situations can drag on for quite some time and be very negative. I'm a very positive thinking person. I like to always look for positive solutions and positive outcomes, and for people to get on. So that's always my drive, that I'll kind of try and encourage people to think with that same mindset.
Yeah, because I was mentioning before we started the interview that I I have seen your success stories on Facebook where you have posted on the Families Need Fathers website, page. And that's when I thought I really need, because I've been meaning to get more information about, McKenzie Friends and the roles that they play, because I think a lot of people at the moment who are going through divorce don't realize that there's so many other ways of going through the whole process. It doesn't have to be the traditional role of, solicitor and client. There's family mediation, collaborative law, and so on and so forth. And I have seen your posts about the clients that you've worked with, and I think one of the things that I find really interesting about what you're doing, that I don't think gets offered in other situations, is the fact that when people are going through divorce, there's a lot of emotional stuff that they bring with them. And sometimes they have a script and they just want to literally throw out everything. Yeah. When you do that with your solicitor, you are wasting a lot of time and a lot of money. You can't do that in front of a judge. In a family mediation session, it's also timed and you need to use the session carefully. So sometimes is where do you take all that emotional stuff? And if you can keep the people focused, like you said, when we go to court, this is what they want to hear, not this. You can tell me this, but this is what they want to hear. Yeah. I think
ultimately, there's aspects of that kind of come into my work. I do try and, I'm very aware that some of the people that I do help, budgets are of a consideration. After I speak to anyone for about half an hour free consultation, and then after that, my time has to be paid for, because this is how I kind of make my living. But I think I can be very clear with people about, okay, if you have limited resources, here's the limit. If you listen very intently and clearly to what I say, I can give you clear factual advice about what's going to be relevant on that day. Sometimes some of the more kind of softer stuff, which is about how to deal with it emotionally, that sometimes kind of happens in the time before the court. Sometimes it's very common to go to court and a hearing to be listed for 10 o'clock, and you might not get heard till 11, 12 o'clock, because of delays, because of negotiations. And courts are ever-changing kind of situations, really. They may have emergency applications that suddenly prioritise. So I very much am constantly kind of, there's numerous ways in which I think there's certain things that I bring to the McKenzie Friend work just naturally as a person that come from my kind of life experience. McKenzie Friends tend to work independently. I do work in collaboration with a small number of other McKenzie Friends. For example, if I'm busy on one day and somebody is desperately looking for short notice support, I can try and refer them on to other people. But like anything in life, if you get in contact with a McKenzie Friend, you need to feel that you've got a connection with that person, a bond, a trust. A lot of it is about trusting and connecting with somebody. I have had people that have called me and said, I've been with another McKenzie Friend, but the way that you speak to me, you're talking about my language. I understand, so I think that's kind of important for your kind of readers, is to understand that McKenzie Friends are out there, and there is a diversity of them with different life experiences, different people styles, and so it's really for them to realise, that they have to find somebody who they feel a connection with. I do sometimes get calls from people and maybe they just don't connect with me, or sometimes I might ask them questions that are quite straight to the point and they don't really want to answer them. But ultimately those questions, the reason I'm asking those is those will get asked in court. So, I'm in some ways trying to prepare you for that experience. If these things will become a reality quite quickly in court, so you need to, be aware of that as well.
Yeah. So, Graham, if anyone wanted to get in touch with you, where can they find you?
Well, I'm on Facebook. If you just search Graham Fletcher McKenzie Friend, I have my own website, which is www.McKenzieFriendUK.com. You can call me on my mobile, which is 07906 956 035, or email me at GrahamFletcherMcKenzieFriend@gmail.com. Okay. I normally get back very promptly within the hour or two, depending whether I'm in court or not that day. And
And do you travel? Because if you're going to represent, if you have a client who's, I don't know where you're based. Where are you based?
I'm based in Berkshire, sort of about an hour west of London. So I'm frequently down in Portsmouth, Southampton, sometimes Birmingham, London, Reading, Basingstoke. Constantly travelling in all sorts of different directions. But I'm placed quite centrally, close to the M4. So that's quite common for me to be travelling in all sorts of different directions.
Okay, thank you so much, Graham. Thank you for taking the time to speak with us. So thank you so much for joining Graham and I. And don't forget to subscribe to the divorcemagazine.co.uk YouTube channel. And if there's any questions that you might have for Graham, he has given his details and you know where you can reach him. Okay, thank you so much. Take care. Bye-bye.